Welcome back to the Thinking Crypto podcast, your home for cryptocurrency news and interviews. With me today is attorney John Deaton, who's no stranger to the show, and we're going to discuss all things SEC Ripple XRP LBRY and much more. John, great to have you back on.
Thank you for having me, Tony. It's always a pleasure to be with you. You know, I'm a big fan of yours and love what you're doing.
Well, John, as always, thank you for the work you're doing. I know it's a sacrifice of your time and resources and so forth. And I couldn't believe it when the SEC tried to kick you out of this case and remove your amici status over some nonsense. Tell us about that and the judge's response as well.
Yeah, you know, I was a little surprised this time. The first time the SEC attacked me, I had actually predicted it. And I had sent an email to Moon Lambo and to the guys, Chip and Jeff on the chain. And I laid it out. I said, I guarantee you they're going to attack me. And that was sort of expected. This time, I was a little surprised that they would go that vicious and attack me personally without any new information. And so what they did is they said to the judge that, hey, because Deaton named one of our experts' name, he needs to not be involved in this case because it caused harassment of our expert. And judge, look at this tweet that he did, 2 years ago, and look at this mock cross-examination he did, stuff that they had already argued. I did a mock cross-examination for fun. It was satire, right? I was like trying to entertain people. And I put my cousin Vinny clips in it, right? And it's me, and I'm playing clips of Jay Clayton, and I'm looping things, and I have side effect, silly stuff. And it would be a valid criticism to say it wasn't funny, you know what I mean? Or something like that I failed in my mission. But they started saying that I was promoting drug use and that I was actually physically threatening Jay Clayton. And they had already argued this, though, with her the first time. When I filed the motion to intervene, they were like, look, Judge, this Twitter guy, he's chasing clout on Twitter, and he's threatening this, and he's doing this, and he caught us a innovation killing cesspool of corruption. Look at all his mean tweets at us, Judge. And she considered it all and granted me amicus status. And so then when I filed the motion saying I wanted to participate on behalf of XRP holders to this expert and his qualifications, because he's going to testify as to what Tony's mother thought in her head when she acquired XRP. He's going to talk about what John Deaton thought when he acquired XRP. And I simply was saying, hey, there's 70,000 of us that I know. They're friends of mine that are sending me affidavits and all this. This is something we might want to be heard on. And that's all I did. And they tried to throw me off the case, get the judge to literally say that I could not participate any further in any proceeding, and that the amici status should be revoked. Tony, a very extraordinary thing you would request. And normally you would request that if I had committed fraud upon the court, if I had personally threatened their experts, or there was some evidence. Their evidence apparently was somebody on social media that I have no control over who may have made fun of somebody, right? Yeah. Well, look at my Twitter feed. There's people that call me ambulance chaser, clout chaser, Twitter this, Twitter that, a fake attorney. I'm a paid shield by Ripple. I'm this, I'm that. It's all nonsense. You just got to ignore that.
Yep.
But the SEC, and I think people need to know what that means. For them to go that personal and to try to get our status revoked, it meant that they're worried. Mm-hmm. They're worried. And Tony, there's a saying, right? When you can't attack the message, you attack the messenger. And that's what they did. But they made a critical mistake because it allowed me to say to the judge, look, Judge, They've offered you nothing that I've done since I've been granted amicus status that warrants this extraordinary thing that they want you to do. Judge, you want to know what's at play here? What's at play here is they're really retaliating against me because I have led the charge for the investigation of Bill Hinman, his emails, and the Connect to Congress campaign that's led to 60,000 messages to all the senators. Recently, Warren Davidson had asked the director of enforcement in the hearing, was the speech, was it cleared by ethics? I mean, that was asked in a congressional hearing. And as you know, something we'll probably talk about, as I said to the judge, the Hinman emails have dominated this case. There's been litigation for 2 years on these emails, and it's still going to continue to dominate the case because they filed a motion, to Judge Torres now related to the emails. And I says, this is why, look, and it allowed me to show the judge that this isn't a conspiracy theory, that there was a conflict, that the SEC ethics office actually said to Bill Hinman, you are prohibited from contacting Simpson Thatcher. And he continued to do it again and again and again. And the evidence was there and I was allowed to submit it. And, the great thing about it is, Tony, is it was a total victory for XRP holders. And I'll tell you why. A lot of people, they think because the judge, technically, she denied my request for now. She basically said that, John, on behalf of XRP holders, you don't get to write a brief right now to talk about this expert. But when you write your brief for summary judgment, you can ask permission to make points related to the expert later, right? Now, why does I think that's a total victory? For one, I don't have to write anything right now, right? Because I would only have like a week. You wouldn't even be interviewing me right now. I probably wouldn't be shaving and I'd be stressed out and all of that. So I don't have time. So that's a victory for me personally. But so she basically ignored the SEC's request to revoke amici status and to throw me off the case. And to me, what that meant was the judge was saying, I'm not even going, it doesn't even deserve for me to address it. It is so pathetic. You know what I mean? And to the SEC attorneys who are watching this, it's pathetic. And you should be ashamed of yourself to get that personal when you don't even have any new evidence. And all you're doing is, making a mockery of yourself.
Yeah. The thought that came to mind when I heard this, I was like, desperation. They seem a bit desperate here that, to your point, they're attacking you personally. And the thought that keeps coming back to my mind is, how is this a government agency operating like this? And I go back to Greg Kidd, talking about they're operating like the mafia, like Tony Soprano. It's unbelievable, right? And then I'm like, my tax dollars are funding this. This is ridiculous.
Well, listen, not only your tax dollars, but there's somebody watching this who's assigned to the SEC to monitor me, right? Mm. All my tweets, any interviews I do. I mean, I was on a link to call for like 20 minutes and somebody got on that because they cited something I said in the link to call, right? Which wasn't anything controversial or anything like that. And so that's kind of strange, right? And so I agree with you, but it's just kind of pathetic that it's come to this. And I'll tell you what it really is. These lawyers at the SEC, Tony, they're smart. Like they're smart attorneys. And I want to make this clear. I'm not talking about the staffers, the staffers, the paralegals, the people down the chain. They're probably wonderful human beings, hard workers, and probably, are doing a great job. I'm talking about the leadership, which are like political appointees, the directors and the chairman and all of that. These lawyers, though, they go to Ivy League schools, right? Look at their resume, Harvard, Yale. They probably scored a 1580 out of 1600 on the SATs. They probably outdid me on a law school admissions test. If they took a standardized test, they probably would double my score, right? They're probably intellectually smarter or have a better vocabulary and all those things. But they're so spoiled that they're used to steamrolling people. And the first time someone fights back, look how they react. These are spoiled, prima donna kind of like people that have never faced adversity. Because if I were the director of enforcement, or if I were the chief, you want to know what I'd say, Tony? I'd say ignore the Twitter guy. Ignore Deaton. He's going to say what he's going to say. He's going to do what he's going to do. He represents these people. They got a voice. Good for them. Let's stick to the law. Let's stick to the facts. Let's do our job. And let's leave it at that. But that's not how they're acting. They're acting like spoiled, petulant children who didn't get their way. And they're crying to mommy, look, he's mean. He said something on Twitter.
Well,
listen, I'm a Marine. I grew up from Detroit. I'm a little harder than a lot of people, but that's a kind of sensitivity that I think is a little bit unhealthy.
Right. And then the other part of it is we're in the United States. We have free speech. Yes, there's a line that you can't cross with death threats and all that, but sure, you have the right to your opinion and to voice that opinion. And we have social media and we can voice it on there. So they're going against free speech in a way that you're not allowed to say anything.
Well, yeah, listen, this is what they were mad at. They were mad that I said that, I learned a long time ago in Detroit what you do to a bully. You punch the MFer in the face, right? That's what I said. I said MFer, those words, the initials. I also said that the SEC has developed into a blood-sucking, innovation-killing cesspool of corruption. Okay? Now, is that harsh? Yes. But is it accurate? Right?
I would say so.
So, and when you look at all of these emails and you look at the Hinman emails and you look at the conflicts of interest and all of those things, there's a lot of truth to everything that I've said. I've always backed it up with facts, right?
Yeah.
And so, they can feel however they want, but we're in the right, and the judge justified it. And this is the final thing I'll say about this is, don't take John Deaton's word for it or criticism. How about Judge Netburn? Yeah. She's the one that said, she didn't call John Deaton a hypocrite, right? She didn't call Thinking Crypto a hypocrite. She called the SEC lawyers were engaging in hypocrisy and that they lack a faithful allegiance to the law. I've never been accused of that. I've been a federal prosecutor just like them. So they can say what they can call me a mean tweeter all they want, but I'm still faithful to the law.
Yeah, absolutely. You hit the nail on the head there because I was about to bring that up. The judge called them out on their hypocrisy. And John, this is getting congressional coverage. I think you hinted towards it. Congressman Warren Davidson, brought it up in front of the SEC enforcement director. And even he refused to answer certain questions. He gave validity to this, that I can't talk about this because this scenario is actually something that took place and is in discussion with the Ripple lawsuit. What are your thoughts on that? And then we also had Congressman Brad Sherman, seems to be buddies with Gary Gensler. There's some kind of battle happening here.
Listen, this is what I would say about the director of enforcement. He said that he could not comment when he was asked the question, was Bill Hinman's speech approved by the ethics office? He said, I can't comment because of ongoing litigation. Tony, that's not being litigated.
Yeah.
He is 100% capable of answering that question under oath in a congressional hearing. Ripple is not claiming that the case should be thrown out because he violated a criminal conflict statute. That's not being litigated, right? At all. So why couldn't he answer that question? He ran from that question. You know, people say, well, why didn't he answer the question? He didn't answer the question because he's afraid of the truth. Because he could say this, right? He could say this, Congressman, I'm not going to get into the details because the speech is being litigated, but I will tell you this, all proper procedures at the SEC were followed regarding that speech. That would include ethics screening, right? If that happened, what would prevent him from saying that? Bill Hinman has been asked to comment by Eleanor Terrett and Charlie Gasparino and others, and there's been no comment made, all right? All because of alleged investigation. Your ethics are not being litigated by Ripple. So you could come out and say the speech was cleared by the ethics office. What is the harm of that? If that happened, why can't you say that?
And John,
it didn't happen. It didn't happen. That's why you can't say it.
Yeah. And it's so funny. I tweeted about it just earlier. Commissioner Jackson, we had the director or the SEC chair, Jay Clayton, and of course, Bill Hinman, all publicly came out and referenced that speech and as if it was the source of truth and gospel. Why is it now these folks can't follow in the footsteps of their predecessors if they're using the same measuring stick and same standards? Clearly, there's a disconnect. And to your point, that speech was not green lighted by the ethics folks.
Well, it couldn't be because it doesn't take, it would take, anyone could figure it out. Tony, you know, I've tried to tell people an ethics screening would simply be the speech isn't that long. It's 5 pages. And all you would do is you would look and you would see, if you were in the ethics office, Bill Hinman is going to say publicly that Bitcoin and Ethereum are not securities. Now, you tell me, Tony, you've interviewed commissioners from the SEC. How often have you ever seen a leader at the SEC discuss specific tokens?
They don't.
They don't. So on this particular occasion, the director of corporation and finance, one of the highest people at the SEC, comes out and makes market-making news. Bitcoin and Ether are not securities. So as a person in the ethics office, you would say, whoa, that's different. Email to Bill. Bill, before you give this speech, I got to ask you a couple questions. You don't own ETH, right? No. You don't own Bitcoin, right? No. Your family doesn't own Bitcoin or ETH, right? No. All right, let me look at your investments to make sure they're not tied to Bitcoin and ETH, right? If he has Grayscale GBTC, he can't give that speech.
Yeah.
So you find out that there's no personal conflict. Then you go to the next layer. Well, you're still getting a pension and profit sharing from Simpson Thatcher. So is there any connection? You don't even ask Bill. You ask yourself, is there any connection to Simpson Thatcher, Bitcoin, Ether? And you hit Google, right? One search,
yep. Simpson
Thatcher, Ethereum. Hope Ethereum Alliance comes up just like that in a Google search. A 5-year-old could do it, right? And then you say, you look and you see, are there any, what's the division of corporation finance do? It allows IPOs. It approves IPOs. Oh, wait a minute. Simpson Thatcher has a huge IPO of Canaan, which is a Bitcoin and Ethereum mining company. They sell hardware for Bitcoin and ETH mining. Bill, you can't give that speech, brother.
Nope.
That's how it would happen. Tony, it would take no more than 30 minutes to figure it out, right? So that's how I know that they didn't do an ethics screening, because the most basic elementary ethics screening that you could do would uncover this, right? And then what the ethics office would say is, if the Division of Corporation and Finance wants to give this speech, they still can. It just can't be you, Bill, because you have a connection. Your firm has this strong connection. What connection? The Enterprise Ethereum Alliance promotes exclusively the Ethereum blockchain. That means not XRP, not Cardano, not Bitcoin, right? It's Ethereum. And so therefore you're out. That's how easy it would be. And so when everybody hears these people say, I can't speak about this because of the ongoing litigation, they're full of shit, right? They can say it. It's not being litigated. Ripple there's no motion to dismiss the case because of a conflict of interest. If that was happening, then maybe it would be, right? But anyways.
And Judge Sarah Netburn, she ruled that the emails cannot be, or they have to be turned over. What are your thoughts on that? That was definitely a big win. I know the SEC is trying to appeal to Judge Torres to overrule, but what are your thoughts?
Well, it's this is the most litigated thing. When I was telling you about they were trying to throw me and us off the case, I referenced the Hinman emails. When you look back, the first decision was like April or May of last year. So these emails, the judge first said they're relevant and must be produced almost a year and a half ago. And so it's been highly litigated. This last chance was the SEC saying that after she ruled that deliberative process privilege, because it's a personal speech, they put all their eggs in that basket, that it was his personal opinion. And then when she said it's relevant, it must be turned over, they go, oh no, it's deliberative process. And she goes, well, it can't be deliberative process if it's personal. So turn them over. And then they wrote and say, okay, no, it's attorney-client privilege. And every time he was talking to someone at the SEC about the speech, he was seeking legal advice. And at the hearing, the judge was like, called him out on it, said, you're being inconsistent. And that's the decision where she said, enough is enough. You're inconsistent. You're a hypocrite. You have no faithful allegiance to the law, because it really is a clear, attorney-client privilege to attach to those emails. Bill Hinman would have to be a client to everyone that he talked to.
Right.
And the only argument that they could claim is, each leader at the SEC, the Division of Corporation and Finance, it's assigned a special attorney, right? A counsel. Like Hester Peirce has a special counsel to Commissioner Hester Peirce. That would be privileged. So if he had a personal attorney who gave him advice as SEC director, and that I accept would be privileged. But this was, talking to like 60 people on an email chain. There were 56 drafts of the speech. There were comments and commentary about the speech. And so, the judges, I've had enough. It must be turned over. And now they have potentially it's not the last chance, but they're going to Judge Judge Torres, and they're saying that Judge Netburn got it wrong. And they're asking Judge Netburn to overturn, they're asking Judge Torres to overturn Judge Netburn. And I think the chances of success are, let's say 2%, 98% Judge Torres will affirm Judge Netburn. And then, of course, the question is, what does the SEC do? Well, I think we know the SEC will ask Judge Netburn permission to file an appeal to the Second Circuit. I predict Judge Netburn will turn that down and deny that, and then order that they must turn these documents over. You know, that sometime would be before the end of the year. Then the question, Tony, is will the SEC try to do what I did with a writ of mandamus, right? Where they're going to a higher court saying that ordering the judge to do her job. And, you know, they could try that and it could cause a bit of a delay, but that's where we're at now. You know, we're expecting a decision from Judge Torres. It's hard to predict, but I would say by the end of September, we'll have a decision from her.
So this thing could still continue into next year, right? It seems like.
The case itself will, you know, unless there's a settlement, you know, unless there's a settlement where this case won't be resolved in February, absent a settlement. I think that we're looking at a summary judgment decision at the earliest March. Could be April, could be May even. But obviously, if some kind of light bulb goes off, you know, when people ask me the chances are settlement, I say right now, I don't see a settlement at all. Now, if the political pressure builds more and more, and it looks like there's a chance that Congress will pass legislation that gives the CFTC the game, right? If they say you're the referee of this game called crypto, if that happens and Gary Gensler sees that happening, then of course it might behoove him to go to Ripple and say, let's cut a deal, pay this large amount of money. I get to say that, like, I held Ripple responsible and make political, you know, statements, blah, 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 all that kind of stuff. I mean, that could happen, you know, but right now it doesn't look anywhere close to a settlement. You know, now that could change, you know, if Judge Torres rules that the documents must be turned over, denies an appeal, and they go up on a mandamus, and December they lose on mandamus, and they have to turn the documents over in January or something like that, and those documents are bad for them, or they guarantee Ripple's victory, well, then why not settle? If you know you're going to lose, then you might as well take some kind of victory, right? So any of that could happen, but I know a lot of people are hoping that it happens sooner rather than later, and I don't see that happening.
Yeah, and to your point, look, the midterm elections are coming up. It looks like the Republicans are going to win, and a lot of the GOP they oversee, or they're part of the committee that oversees the SEC, and Congressman Tom Emmer kind of issuing a bit of a warning at that hearing to the SEC Director of Enforcement that a new day is coming.
We can't wait, man.
Yeah,
you know.
Yeah. So, you know, things could be changing at a rapid pace later this year, depending on, you know, what happens with the elections. I want to ask you about the LBRY case. What's happening there? And I saw your tweet from earlier today of the impact that outcome could have on the Ripple lawsuit.
Well, you know, the first thing people need to understand is that the LBRY case is in the New Hampshire Federal District Court, and that's in a different circuit in the appellate courts, right? And then the Ripple case is in the Southern District of New York, which is much more high-profile litigation, obviously, in the Southern District of New York, and that's in the Second Circuit. And so Judge Torres has to obey the laws handed down to her from the Second Circuit Court of Appeals. And the judge in New Hampshire, you know, it's his circuit that he has to listen to. And there's some case law in the Second Circuit, the Upton case, UPTON, That's where Ripple is relying on their fair notice defense on that case. Well, that case isn't applicable in the LBRY case. They don't have that kind of case law on fair notice. So there's a very strategic reason why the SEC wants a victory in LBRY. Think of this, Tony. A lot of people haven't talked about this, but in the Ripple case, there was a motion to strike the fair notice defense.
Right.
Right. I know you covered it. And I think we talked about it. In the LBRY case, the SEC didn't move to strike it. Think about that. Well, if they moved to strike it from the Ripple case, why didn't they move to strike it from the LBRY case? It's because they fear it more in the Ripple case, right? Just like they want to throw us out. They fear us, right? Sure. They react to that. In the LBRY case, because the judge doesn't have that good appellate case law on fair notice, they left it. They believe they're going to win on fair notice. And I tend to agree with the SEC, unfortunately, that the judge is not going to grant fair notice in LBRY. And so when the judge does that, they then will rush that decision, and you'll see the SEC file a letter motion to supplement their brief of this new decision that just came down that she must rely on, not rely on, that she should consider. Look, Judge, the judge in New Hampshire struck down the fair notice defense. You need to do the same. We can't have inconsistent law. We always do, but that would be the argument, right? So it's the same kind of thing with summary judgment. If they get a summary judgment win and the LBC token is deemed a security, they'll come rushing to the court and saying that she should consider it. Now, it's not binding. She can reject it and say, that judge in New Hampshire doesn't know what he's doing. I don't care anything he says, right? Or she could be like, he's the smartest judge I ever met. I met him at a conference. Let me read his opinion. And it has some kind of persuasive impact on her. So, you know, you can completely distinguish. What I wrote today was, because a lot of people are going to criticize me and say that I'm putting too much emphasis on the LBRY case, right? I could easily distinguish the LBC token from the XRP token. This is the way LBRY sold the token. This is the way Ripple does. You know, Ripple had venture capital. You know, you could do all these things to distinguish it, but it would be better for crypto if LBRY won, right? It'd be better for, and what I think's happening is this, and people have got to understand, your audience, your viewers need to understand something that I've been trying to say for over a year now. There is a strategic plan in place at the SEC. And I talked about it first when we learned that the SEC doubled their enforcement division for crypto. It was like, okay, they have a design plan. Think about this, Tony. They've got this LBRY case in Little New Hampshire. They didn't hire an expert witness, right? They didn't strike the fair notice defense. They got a good judge for them. They want a decision so that they can say, look, LBRY is a security. Look what they did with Coinbase, the former product manager. Why didn't the SEC sue Coinbase? They sued 3 individuals and said, you sold illegal securities, right, by this insider trading thing. But they didn't sue the exchange selling those 9 tokens.
Yep.
And to your viewers, I tell them, I can tell you why the SEC did not sue Coinbase now, because they're not ready. They're gaining their information. They're building their case behind the scenes. This is what they want to do. The Department of Justice has got to fight a wire fraud case against these 3 people, right? They are charged with selling $1 million worth of insider trading. They're going to face 20 to 30 years in prison. They're going to face bankruptcy. What are the chances that those three individuals, if the Department of Justice and the SEC go to them and say, we want you to plead guilty and you're only going to do 1 year. And you got to pay the $1 million, but you're only going to do 1 year. Oh, in order to do this, you need to plead guilty and admit that you sold securities. Admit that those 9 tokens are securities. And then they admit to it. Now, Gary Gensler says, look, former product managers at Coinbase admitted that these are illegal securities. Look, we got a judge in New Hampshire that said the LBC token is a security. Put it all together and it gives him momentum, right? It gives him props. It gives him whatever you want to call it to say, I and the SEC should control this asset class. Look at that. This is a concerted effort by the SEC. They're not dumb people. We can make fun of Gary Gensler all we want. The dude was the youngest partner at Goldman Sachs in history. Do you think you make the youngest partner in the history of Goldman Sachs for being dumb? No. Probably for being pretty shrewd. Yeah. Probably for somebody who takes that knife and puts it in your back anytime and every time, right?
And to your point, John, also BlockFi security what they would consider, non-registered lending security products and so forth, $100 million. So to your point, he's building that arsenal and that case to say, see, look at all these things and what we've done so far. Yeah. It's
right. And then of course, and right now, we just learned, right, that every crypto exchange in the doing business in the United States has received something, right? They've received some kind of notification from the SEC. And so it is an absolute, trust me, man, that they have meetings every week, like on this plan that they got about how they're going to get their hands on this crypto market. And if we don't have Congress act, and it's an election year. So, Gary Gensler is taking advantage. He knows the chances of bipartisan legislation getting through both the House and the Senate and signed by the president in an election year. It's probably overly optimistic to think that, right? I hope I'm proven wrong. I'll be the first guy to celebrate if they could do something, but I don't think they will. And in the meantime, Gary Gensler is going to do his thing, man. And they're, I said a long time ago, they're coming after crypto.
Yeah, absolutely. You were spot on. And I think a lot of people were not paying attention, because I know there were a lot of people who didn't really like Ripple and XRP, but it wasn't just about Ripple and XRP. They're coming after everything. The lending platforms, the exchanges, everybody.
Tony, think about LBRY, man. Do you want to know how much LBRY raised in the complaint? I've read the complaint. $230,000.
That's nothing.
I'm just saying, it'd be different if they charged Jeff, the CEO, Jeremy. It'd be different if they charged him with fraud. It'd be different if they had evidence that the man misrepresented people and misled them. But who the hell? I'm about to cuss worse, right? The SEC would rush to the judge. But who the hell is LBRY hurting? I mean, think about how many people boy, I bought 10,000 LBC tokens. I hope they go up 35%. I'm going to sell it here. I mean, you just don't hear that. So they're picking a small operation because of the impact that it can have. If they can get a victory, they can spin that victory so much bigger. Because the truth is, the LBC token really is getting used more than it is for investment. Like I'm being honest and objective, right? There are people who are utilizing the platform and they're using it to tip. They're really not using it as like this huge speculative asset class to try to get rich off of. And so if that token is a security, then so many other tokens are securities. And that's where they're going. And so you just got to think about, of all the pump and dump schemes, of all the fraud that does go on that should be cleaned up, why aren't you taking all those resources and going after them? You're going after LBRY for 200 grand. I mean, come on.
Yeah, you know? It's ridiculous. Look, I'm on LBRY. I've been on it for years. My content is syndicated on there from YouTube, and I earned the tokens. I'm not doing anything. Like, I have it within. I could tip people, like you said. So it's really ridiculous. And then to your point, there are a lot of scams out there that you don't see the SEC going after. And I don't know if it's because, to your point, these legit businesses and companies are easy targets because they can just go and shake them down and say, hey, look what we did here. But I don't know if it's harder to go after the scammers.
Yeah, you know, what it is unfortunately, we learned that from Jeremy Kauffman, we learned that he did the right thing and he cooperated and he went in there and he showed them every single, he gave them the evidence and said, here's every single LBRY, like LBC transaction that we've done. And he had a PowerPoint presentation about how it's decentralized to the point where it meets the Hinman test of the speech where it's sufficiently decentralized. And they went in there, he's like, sure, you know, on day one, there were 4 videos, but today there's 15 million. On day one, we only had a handful of people that were going to be users. Now we got over 1.3 million a day. It's a different, you know, system, and we complied and blah, blah, blah. And then they wouldn't do anything. And then he's like, okay, I'll sell my assets. I'll do this. No, we want a verdict, a judgment, and they want a judgment so that they can use it for whatever impact that they can maximize, you know, in the rest of the crypto market. And so LBRY is a concern of mine. And as you know, I went and I watched the speech. I just tweeted a long thread today because I can't release the transcript. I got a copy of the transcript, but there's a rule that you can't release it. I was going to publish it on my crypto law site, but I'm not going to violate the rules. So I paraphrased some and I gave an example of the arguments. Tony, anyone watching this, the SEC attorney admitted to the judge that a lot, maybe even the majority of LBC holders are using it for non-investment reasons.
Yeah.
Tony, that doesn't pass the first prong of Howey. The first prong of Howey is an investment. If it's being used for consumption, right?
Yep.
In use, then it's not. Well, this attorney said 2 things. He said, utility doesn't matter. He said whether the token has utility or not is irrelevant. And even if 90% of the LBC holders acquired the token just to tip people and use the platform, if it can be argued that the price could still go up and they benefit from it, it's a security. And that their subjective intent is irrelevant to anything. I mean, it is obscene is what it is. It's obscene of the unlawful expansion of the Howey test that's going on by the SEC. And, I've done what I could to try to draw attention to it. But, there's a part of me that, like I almost want to try to do something, but I can't because, I'm already tied up with this and I can't try to do too much. It'll look like it's about me and not about, the tokens, but we'll see. I'm a little pessimistic right now about the LBRY case.
I wanted to ask you related to the exchanges with the SEC going after exchanges. We know they blocked Coinbase lending. Coinbase CEO tweeted out the SEC is acting shady. This happened, I believe, earlier this year. And yesterday, a huge partnership was announced that they are partnering with BlackRock. Do you think in some ways that might cause the SEC to pump the brakes a bit, given that you got the big guns coming in, so to speak, with BlackRock in that relationship?
If Larry Fink, who is the CEO of BlackRock, who is, as you know, is the largest, money manager in the world at $10 trillion. If Larry Fink is prepared to call Gary up and say, back off, then maybe, you know what I mean? It's a good sign, but I got to tell you that the part of me is when I was on Charles Payne's show, I had said to Charles, because I had predicted that they were going to go after exchanges on his show as well. And he asked me what I thought was going on. I said, part of me thinks that Gary is crushing the crypto market so that the incumbents can come in and like swoop it up or become partners, right? I mean, can you imagine if you go after Coinbase and the stock goes down to like from 300 to 5 or 6, then all of a sudden, Fidelity comes in and buys 51% or 40%. There's a part of me that thinks that they know crypto's here to stay. Yep. They know it's part of the future. It's one of the few areas where retail and individuals front ran the industry. We got in earlier than them, so they have to crush the market so that the incumbents can get in. We know that JP Morgan's involved with ETH already. We know that, but Goldman Sachs. So I'm not surprised. I think it was a great move by Brian Armstrong because I think Coinbase was starting to experience. There was a lot of talk about Coinbase to go bankrupt. Right? I was someone who said that I never thought that would happen because symbolically, it would just put crypto back so many years. If Coinbase were to file bankruptcy, I mean, I couldn't believe. I wouldn't even think that Sam Bankman-Fried and CZ. I don't even think they would want that, right? Or want that to happen because it would have such a negative perception on crypto. So, and then as soon as I saw that BlackRock deal, I was like, man. You don't get any more traditional finance than BlackRock. Yeah.
Huge partnership. And I'm excited to see what else they do. But one of the things I'm curious about, John, is that, it starts with Bitcoin, the deal that they allow Bitcoin trading custody. Curious if they're going to open the door to the altcoins, given the SEC is out there like a hawk looking at everything and the former product manager. So there's a lot of moving parts here. And I'm curious what's going to happen next as far as which assets are going to be traded via BlackRock.
Yeah, I think it really comes down to how much momentum happens with Congress. If the CFTC, if most of the cryptos, when I say most, I shouldn't say most. When you look at the major cryptos, right, the ones that have been trading for 8 to 10 years, if they're held to be more like commodities, then I think it opens up the door for the BlackRocks, right? Right now, they're talking about the legislation being Bitcoin and ETH are commodities and everything else is in the gray. Is it a commodity? Is it a security? So if we could get legislation that said that the SEC would be in charge of any ICOs, initial coin offerings, where there is no blockchain, there is no platform, you're doing crowdfunding, that's a security. But if it's a token that's been traded like XRP, Cardano, whatever, algo for the last 10 years, that's sufficiently a commodity. And then I think it opens the door to those cryptos. People do not, a lot of people, Tony, think that I'm anti-regulation. I'm anti-over-regulation, but
Right.
What we need is smart, tailored, innovation fostering regulation. For example, like I contacted Fidelity and I said, if hypothetically speaking, if I own a significant amount of Bitcoin, but I don't trust myself with a wallet and the private key, whatever. Do you guys offer individual, will they hold, because I know Fidelity will hold Bitcoin for institutions, right? Will they do it for individuals? Because I was talking to someone, let's say someone that I know that has like 500 Bitcoin or something like that, or 1,000, but they want to go to Fidelity. Fidelity said, no, we won't do individuals until the SEC clarifies it. And that's for individuals, right? And that's Bitcoin. So I think people don't realize how much regulation's holding back the industry and the lack of clarity. You know what I mean? XRP holders know it.
Yeah.
But I'm talking about the non-XRP holders. Like even Bitcoin isn't being touched in some categories because of the SEC. Now, if the SEC were to grant a spot Bitcoin ETF, right?
Yep.
I bet my friend could go to Fidelity and get somebody, you know what I mean, to do it. I'm trying to teach him about the personal wallet stuff, but it's not working.
No, you brought a great point, and we've noticed, to your point going earlier, that Gary Gensler trying to help these incumbents get a hold of the market. They've approved the futures ETF, and they just not too long ago, a couple of months, a short ETF. So you can short this asset class, but no spot ETF.
Right. Well, and who benefits from a futures and a short?
Yep.
Right. Professionals,
exactly.
Hedge funds, professional investors, professional traders, right? The average Joe isn't going to necessarily be sophisticated enough to deal with futures and options and all that stuff. And so spot Bitcoin ETF, that's what's holding us back. So it's just another example where, listen, the more partnerships we see, like the one you brought up with BlackRock, I guess the closer we are to getting past this awful stage of regulation, suppression, and everything that's happening in this community, because, it's exhausting, and it's unfortunate that, you've got Singapore and the UK and all these other countries talking about they want to be the hub. They want to be the crypto hub of the world. And in the meantime, you got Gary Gensler or this SEC attorney in LBRY saying, if you have any expectation of profit for any item, it's a security. Like that's just, we've reached a level of absurdity in the United States.
Yeah, it's ridiculous at this point, and hopefully Congress can act soon. I see a lot of bills coming in. A lot of different folks are putting out things. So hopefully, fingers crossed, they can get something done or by early next year at least.
I hope so. At a minimum, I just want to see, Gary Gensler sitting in that seat at the Congressional hearing, right? Because I believe that if the House gets overtaken and the Senate, and you have both the Senate and the House, asking for Gary Gensler to show up and justify all of this, I think he taps out and resigns. You know what I mean? So,
well, John, I think we can end it on that note.
On a positive note.
On a positive. Thank you so much for joining me. I appreciate everything you've done, and I appreciate all the thoughts and things you shared with me today.
Thank you so much, Tony. Appreciate it.